which was raised when counsel for the first respondent decided to close their case without calling Mrs. Jean Mensah to testify, contrary to what she herself had indicated in several dispositions on oath before the courts. Now, you would recall that in the court's decision on that objection, they indicated that a party cannot be compelled to adduce evidence, and so they dismissed the objection raised by counsel for the petitioner. And so today's review application sought to demonstrate to the court that that decision was based on fundamental errors of law, which has occasioned a miscarriage of justice to the petitioner. And the grounds that counsel for the petitioner argued was that, number one, the decision of the Supreme Court on that matter was per incurium. Per incurium basically means that it was without regard for the law. And what law are we talking about? Section 26 of the Evidence Act. Because what counsel basically said was that, yes, we know that a party cannot be compelled to give evidence. That is trite legal learning, and we are all very familiar with that. But we are also aware of Section 26 of the Evidence Act, which establishes the principle of estoppel, that even though you are entitled to do something, you can be entitled to do something in law. But if by your own actions or conduct you make another person believe that you will not do that which you are entitled to do under the law, then the law must not allow you to resile from that position. The law must not allow you to change your position. That is what is meant by estoppel. And so, counsel for the petitioner's argument is basically that, yes, the first respondent is entitled not to adduce evidence like any other party in court, but because Mrs. Jean Mensah, as a witness, had already elected to give evidence per several depositions in her affidavits before the court. And when we talk about an affidavit, we are talking about depositions under oath, that the court should not allow us to ask her questions through interrogatories because she will be available for cross-examination. We were of the opinion that on the basis of Section 26 of the Evidence Act, she was stopped from resiling from that, and that granting her the right to change her mind will amount to her playing tricks on the court, because you cannot say in one breath that I'll be available for cross-examination to answer certain questions, and then when it is time for cross-examination, say that, oh, I'm no longer willing to do so. And so the court should not allow her to do so. And counsel today in the application for review argued that the court's ruling did not comply with Section 26 of the Evidence Act. In fact, the ruling made no reference whatsoever to Section 26 of the Evidence Act. And so, in our opinion, that was a fundamental error of law, and that renders the decision per incurium and should be reviewed. Again, counsel argued that the courts in another matter, the Sumaila Bilbo case, had established clearly that even though a party is entitled to give evidence in support of his or her case or not to give evidence, in that case, the defendant, the first defendant, elected not to give evidence, but the court compelled the defendant to enter the box and give evidence. Why? Because the court said that it is in the interest of justice that the first defendant, having given certain depositions in certain affidavits, enter the box to give evidence. And so, by parity of reason, counsel for the petitioner argued that that same principle should be applied to this case, because the interest of justice demands that Jean Mensah, having intimated to the court that she will be available for cross-examination to answer certain questions that are pertinent and germane to the issues before the court, should not be allowed to resile from that, but she should be bound by her own depositions. Again, counsel drew the court's attention to another fundamental error of law they made in their ruling on his objection, you realize that in the ruling, the court relied on Order 38, Rule 3E1 of CI 47 as amended by CI 87. And counsel's position, which is the position of the petitioner, is that that order that was more or less the basis of the court's ruling was not part of the submissions of counsel for the first respondent and the second respondent. In arguing or in opposing counsel for the petitioner's objection, they never made reference to that order. That order was rather suggested by the bench, specifically Justice Apau, because they came under Order 36, Rule 4.3, and Order 38, Rule 3E5. They did not come under Order 38, Rule 3E1. And so why would the court base its decision on a rule that the respondents never came and it never invoked? Then counsel for the petitioner also addressed this issue about, oh, the petitioner keeps on saying that Madam Jean Mensah has a duty, a constitutional duty to the people of this country to testify and to provide answers to certain pertinent questions that are germane to the issues before the court. And why are we saying so? Because the fact that she is EC chairperson doesn't mean that different set of rules should be applied to her. Counsel for the petitioner today argued that we are not asking the court to subject Madam Jean Mensah to a different standard. We are asking the court to subject her to the very rules that every other person is subjected to. And that rule is simple. You, Jean Mensah, you were the returning officer for the 2020 presidential election. You conducted the election and declared the results of sin. In your declaration, you stated that the total valid votes for the election was 30,434,574. And then you stated that candidate Akufo-Addo got 6,730,413, constituting 51.5%. We took our calculators and did the same calculation, and we saw that if you divide 6,730,413 by 13,434,574, you don't get 51.595 as we gave him. You rather get 50.089. And so why did you increase the votes of the second respondent, candidate Akufo-Addo, unjustifiably, when your own figures don't support that? And in your own declaration, after you made this flawed, you gave him this undeserved petition, you proceeded to say that even though you did not have the results for Techiman South constituency, you were not going to wait for that, because even if all the votes in Techiman South were added to that of the second candidate Mahama, candidate Akufo-Addo will still cross the more than 50% threshold. And we took our calculators again and did the calculation. The total votes in Techiman South are 128,018 votes. If you add that to the total valid votes she declared, 13,434,574, you get 13,562,592. And if you divide candidate Akufo-Addo's votes, 6,730,413 by that figure, and you multiply it by 100, you get 49.625. That is the figure candidate Akufo-Addo got per Jean Mensah's own declaration, per her own figures. And so if, subsequent to that declaration, you claim to have made a mistake, in fact, so flawed was that declaration that if you added all the percentages given to the 12 candidates, you get 100.3%, a clear mathematical impossibility. Then this woman comes to tell the nation that I've made a mistake. And in rectifying that mistake, an unsigned press release is issued. An unsigned press release, therefore, in our opinion, cannot be a declaration or a rectification of the alleged error. And even in that unsigned press release, different figures were issued or put out, 14, 433, 533, different figures. And contrary to what she herself has stated in that unsigned press release, that she was only introducing a new figure for total valid votes, she actually massaged or adjusted the votes of the candidate, reduced that of Mahama by 1,707, and that of candidate Akufo-Addo was increased by 174. Subsequent to that, she came to court. All Ghanaians thought that she was going to rely on her so-called correction, only to abandon the so-called correction she had told the nation through that unsigned press release. And then came to court with another figure, 13,121,111. And then abandoned the votes she gave candidate Mahama and candidate Akufo-Addo on the 10th, and went back to the votes she declared on the 9th. And then you go on their website, you see different set of figures. You check the 16 regional coalition fees, you see different set of figures. And so we are saying that her own conduct, which is the subject of this petition, makes it imperative for her to testify and provide answers to all these issues, so that the court and Ghanaians at large will know the truth in this matter, and so that justice will be done. And so we are not saying that different set of rules should be applied to her. We are saying that as a public officer, she should be held to account, particularly when she herself had already intimated to the court that she will be available for cross-examination to provide answers to some of these questions. And then last but one, Council raised a very important issue that we want to stress, the issue of fair hearing. Now, all these applications we are bringing before the courts, at the heart of these applications is the issue of fair hearing for the petitioner, and by extension the people of Ghana, because the petitioner is doing this for and on behalf of all of us. And that having relied on that representation by Madam Jean Mensah, and having closed our case based on that representation, we will be denied fair hearing if she is not held to her own representations conclusively under Section 26, because under Section 26 and 24 of the Evidence Act, she has put herself under a conclusive presumption that she will testify. And we think that it will not be fair. The petitioner will not have fair hearing if this is denied. And then finally, ladies and gentlemen, counsel argued that
the female judge, the breach,
the court itself, when counsel was arguing, the objection he had raised, made a point that, counsel, are you saying that she is stopped from changing her mind? I'm sure you all remember one of the justices of the bench asking lawyer Chachuchikata then that, so can't she change her mind? It was all in reference to the issue of Estopel. So why the court did not make reference to that and deal with that in this ruling, for us, is a grave, if you like, violation of the law. Now, in the court's decision on the matter, they simply said that they disagree with us because we have not shown that these fundamental errors of law have occasioned any miscarriage of justice to the petitioner. And that is why we vehemently disagree with the court. We respectfully but vehemently disagree with the court, because these applications are not being brought for nothing. We believe that in line with Article 19, Clause 13 of the 1992 Constitution and Section 26 of the Evidence Act, Jean Mensah must be made to testify based on her own election and to answer questions that are germane to the issues before the court. And that refusing that would deny the petition of fair hearing. What else do we need to prove before the court will know that their non-compliance with Section 26 respectfully has occasioned a miscarriage of justice to the petitioner? Because that is without saying, it is a given that their non-compliance has occasioned a miscarriage of justice to us. So what we want to tell Ghanaians who are watching this briefing, particularly the over 6 million Ghanaians who voted for His Excellency John Dramani Mahama, is that some of these decisions are not going in our favor. And there is a tendency for some of you to be crestfallen and sad. But we are standing here as leaders who have the authority of His Excellency John Dramani Mahama to tell you that don't give up and don't give in. Chin up, square up your shoulders, because no matter how this court decision will go, no matter how it will go, Ghanaians, all of us are discerning. The world is watching. and we will all know the truth for ourselves. Thank you very much. If you have any questions, you can ask.
My name is Kwekwa Sante, Joy News. Among other things, you've cited some of the things the court said for which reason. Okay, so among the points you've raised in the ruling of the court also says and agrees with the respondents that your review application was simply to re-argue the points that you've made in
maybe you heard that from counsel for the respondents, okay. But that definitely did not come from the bench.
Right. Let me go to the ending of what happened in court today when Mr. Tashishikata wanted to, in terms of the stay of proceeding, the court has struck out the application as moot because the application was predicated on the review that has just been disposed of.
Yeah.
And so if you are insisting that it moves to Monday, then...
And counsel for the petitioner didn't disagree with that position. Just that a certain indication had been given to him by the bench that we should come back on Monday. Because whether or not you withdraw that voluntarily will have a bearing on pending orders of the courts. And so we all know that since the review application has been heard and determined, it rendered that application for stay moot. That is right, we all know that. But the most important thing is that there is another application for review in connection with the ruling of the court on our application for leave to reopen our case and to subpoena Mrs. Jean Mensah. That application will be heard by the court on Monday, and there is a stay of proceedings attached to that as well. So that will be heard on Monday. And so we are exploring all options, and we are fighting this case to the very end. And we are assuring all our supporters and all Ghanaians to be patient. Yeah,
two quick questions. One on the call it admonition, the encouragement given to supporters across the country, the note on which you ended the main address. How much disaffection or how dissatisfied are your supporters across the country in what you have described as the case not going in your favor? And is that in any way influencing the next steps we are seeing on Monday, irrespective of how the Monday application...
I didn't get your question. Are you saying that what?
How dissatisfied are your supporters across the country? That dissatisfaction, will it in any way inform your next moves from Monday, irrespective of how the application goes on Monday? The second quick one. There are reports in sections of the media of a contempt case against the lead spokesperson for the team. Indeed, he's the one who usually addresses us. Today he's not here. I was hoping to ask him whether indeed that he's been served that contempt and charges, and when he's responding to them. Is that okay? The reason he's not here?
Okay, thank you very much. First of all, we are in no position to anticipate the decision of the courts on the applications pending before it, which will be heard on Monday. And we are in no position to anticipate their decision on this matter. And what we have said is that no matter how it goes, Ghanaians can discern the truth for themselves, and we will all know the truth, and the truth will set us free. And so we are determined that regardless of how many interlocutory applications, are determined in a certain way, we are not giving up, we are not giving in, and we are doing this for God and country. We are doing this on behalf of the over 30 million Ghanaians who have promulgated for themselves a constitution which says that one can only become a president only when that person gets more than 50% of the total valid votes in any election. Candidate Akufo-Addo did not get more than 50% of the total valid votes per CI 135 and the declaration of the returning officer. And therefore, we will challenge it, and go the full haul and ensure that justice is done. Now, to your second question. First of all, Dr. Ayine is not in court today and is not with us here because he lost a friend. and he had to go for the funeral. That is why lawyer Tony Letta is also not in court. So he's not in court, not because of any alleged contempt proceeding that has been brought against him. Number two, officially, we are also not aware of any contempt proceedings that has been brought against him. We've seen a publication by Asase Radio which makes reference to no process, and we don't know how they got that information, so we will wait and get confirmation of that before we can make our position on that known. But be rest assured that Dr. Ayine is a senior member of the bar. He will not deliberately disparage the court or seek to scandalize the court in any way. And he is capable of explaining these issues in a way that the justices of the Supreme Court and Ghanaians at large will appreciate when that time comes. But, or if that time comes, let me put it that way. But the party has issued a statement on this issue. Not necessarily the committal for contempt proceedings and all that, but statements that have been made by spokespersons of the second respondent, candidate Akufo-Addo. And here we are referring to people like Kojo Oponkroma, Nana B, who at this very platform and on different platforms have sought to deliberately instigate and incite the courts against Dr. Ayine. We want to condemn in no uncertain term that shameful conduct of our colleagues, because as lawyers, that attitude is completely shameful and unacceptable. They know that Dr. Ayine did not say what they have said he said, and they know that the interpretations they are putting on what he has said are slanted and false, and they know that even if any of us here are in breach of any law or stand the possibility of being held liable for contempt, it is absolutely wrong for colleague lawyers to be the ones fanning the flames. We're all in this country during the 2013 election petition. We saw people from the NDC and NPP be cited for contempt, and you saw the unity at the bar between all the parties in defense of these people. When my own brother Sammy Gyamfi was cited for contempt, you saw how lawyers for John Mahama at the time and the NDC defended him. And I believe the other side also did the same thing for my own brother and colleague Kweku Buai. Why are lawyers like Kojo Oponkroma, Nana B, who by the way are juniors by far to Dr. Ayine, trying to instigate the court and incite the court against him on the basis of things he has not said, and when they have made worse statements than that are even more contemptuous? Because my brother, the court, I believe, has been very liberal in how it has conducted these proceedings, and even where senior lawyers who are on record have heard, the court has been very liberal in giving them, cautioning them here and there and all that. You saw them do that to Francis Davies and other senior, Frank Davies and other senior lawyers. Because if the broad rules of contempt are to be applied strictly, then the first culprit will be Kojo Oponkroma. Because nobody has prejudiced this matter, which is sub judice, than him. How many times hasn't he stood here to dismiss the case of the petitioner? How many times haven't you heard Nanabi say that petition, I told you, the petition is baseless. The petitioner has not discharged his evidential burden or the burden of proof. Are they justices of the Supreme Court? Are they clothed with power to pronounce definite conclusions on matters that are sub judice? That is also contempt. Yet nobody has called on the court to cite them for contempt. So they should stop this shameful conduct. And finally, let me also raise this point, which is tied to what we are talking about. The disrespect from spokespersons of the second respondent for lawyer for the petitioner, in the course of these proceedings, for us is very unacceptable. You hear them stand here and describe things that counsel for the petitioner has said as English and grammar. Lawyer Chachuchi Katai was just speaking English and not law. You don't do that. We are not trained to say things like that about our seniors at the bar. All these people are juniors by far to the people they are trying to ridicule. When we come and stand here, we don't ridicule the likes of Senior Kutuampao and Justin Amenuva. We all see how they struggle on their feet, yet we don't come here to mock or ridicule anybody. You understand? So, I mean, why do you come and stand here and talk down on somebody that you may never be able to even come close to what they have attained or achieved in life? I'm not sure that even President Akufo-Addo would disrespect Lawyer Tetuchi Carter. So let us uphold the ethics that we have been taught as lawyers and give respect to whom respect is due, and stop instigating the courts against seniors, stop ridiculing seniors. We are not supposed to do that. We should know better.
I'm sorry, because of time, we may have to regulate this. Yes, but there was a bit of my question about disaffection amongst your followers that you have not addressed.
There is no disaffection. We are leaders and we are providing leadership, and we are telling them not to give up, because we are not giving up. The truth at the end of the day will become clear to everybody, no matter how this decision goes. That is the assurance we are giving them.